Sahaj Vidhi www.sahajvidhi.in Question 1. D. If Article 21 confers on a person the right to live a dignified life, does it also include a right not to live? Examine the constitutional provisions with the help of decided case laws. Model answer: Article 21 of the Indian Constitution, which states, "Person shall be deprived of his life or personal liberty except according to procedure established by law," has been expansively interpreted by the Supreme Court to encompass a wide array of rights essential for a dignified existence. While the right to live a dignified life is firmly established under Article 21, the question of whether it includes a right not to live, i.e. the right to die, has been a complex and evolving legal battle, with the judiciary drawing crucial distinctions. The right to live a dignified life, the Supreme Court, through a series of landmark judgments, has broadened the scope of Article 21 far beyond mere physical existence. It has been interpreted to include. Maneka Gandhi v. Union of India, 1978 established that a procedure established by law must be fair, just, and reasonable, effectively introducing the concept of the due process of law into Article 21. Olga Tellis v. Bombay Municipal Corporation, 1985 held that the right to life includes the right to livelihood, as no person can live without the means of living. Subsequent judgments have included rights such as the right to a clean environment, health, education, speedy trial, privacy, shelter, and access to justice, all contributing to the concept of a dignified life. The right not to live, right to die. The judiciary has consistently distinguished between the right to die, including suicide, and the right to die with dignity. Passive euthanasia. 1P Rathanam vs. Union of India, 1994. A2 judge bench of the Supreme Court initially held that the right to life under Article 21 does include the right to die. The court reasoned that if the right to live includes the right to live with dignity, then by extension, it must also include the right to end one's life when life is no longer dignified or meaningful. Consequently, it declared Section 309 of the Indian Penal Code, IPC, which criminalizes attempt to commit suicide, as unconstitutional. 2. John Kaur v. State of Punjab, 1996. This landmark 5-judge Constitution bench overruled the P. Rathanam judgment. The court held that the right to life under Article 21 does not include the right to die. It clarified that the right to life is a natural right, while suicide is an unnatural termination of life. The court emphasized that the right to life with dignity means the right to live a full life, and not the right to prematurely end it. It distinguished between the right to die with dignity, which could imply a natural, peaceful death, and the right to die by unnatural means. No. Section 309 IPC was thus restored as constitutional. 3. Aruna Shanbhog v. Union of India, 2011. This case brought the issue of euthanasia to the forefront. Aruna Shanbhog was in a persistent vegetative state, PVS, for decades. The Supreme Court, while reiterating that the right to life does not include the right to die, made a crucial distinction between active and passive euthanasia. It rejected active euthanasia, administering lethal substances, but allowed for passive euthanasia, withdrawal of life support, in exceptional circumstances for terminally ill patients in PVS, subject to stringent guidelines and high court approval. This was seen as an aspect of the right to die with dignity, not a general right to die. 4. Common Cause, a Registered Society v. Union of India, 2018, equals a 5-judge Constitution bench affirmed the right to die with dignity as an integral part of Article 21. It recognized the legal validity of wills or advance medical directives, allowing competent adults to refuse medical treatment in the future if become terminally ill or enter a PVS. The court laid down comprehensive guidelines for the execution and implementation of such directives, involving medical boards and judicial oversight by the High Court. This judgment solidified the right to refuse treatment and ensure a dignified end, but strictly within the framework of passive euthanasia and with robust safeguards. Conclusion equals while Article 21 guarantees the right to live a dignified life, the Indian judiciary has consistently held that this does not extend to a general right to die or to commit suicide. The right to life is interpreted as a positive right to live, not a negative right to extinguish life. However, the concept of right to die with dignity has evolved, allowing for passive euthanasia in specific, extreme circumstances for terminally ill patients, either through advance medical directives or judicial intervention, subject to strict legal and medical safeguards. This distinction is crucial. The Constitution protects the right to live a full and dignified life, and in its final stages, the right to a dignified death, but not the right to prematurely or unnaturally end one's life. Please visit our website www.sahajvidhi.in for more content. A living their life.